Good morning. This is the clerk of the court, and it is 10 a.m. in Washington, D.C. Judge Toth, the conference is configured for oral argument this morning with recording and live video streaming now up and running. Counsel are prepared to argue, and all participants are ready to proceed.
Very good. You may call the court.
The United States Court of Appeals for Veterans Claims is now in session. The Honorable Joseph L. Toth presiding. God bless the United States and this honorable court.
Good morning. This is Judge Toth, and I'm joined by Judge Laurer. We are convened today via video conference to consider arguments in the matter of John A. Cooper versus Dennis McDonough, Secretary of Veterans Affairs, case number 23-5963. Will counsel, beginning with the Secretary's counsel, please make your appearance for the record.
Good morning, Your Honor. This is Alexander Yu representing the Secretary.
Good morning. Would you, Mr. Secretary, would you like to have reserved time for rebuttal?
Yes, Your Honor. We would like to reserve 10 minutes.
Good. Thank you. Counsel.
Good morning, Your Honor. Attorney Ken Eiler is appearing this morning on behalf of the appellant, Mr. Cooper. With me on behalf of Mr. Cooper this morning is Attorney John Niles.
Okay, good. So I just want to go over one thing before we begin. So Judge Greenberg will not be present or will not be on the argument right now listening. He will listen to this argument later today, and he will participate in every respect in the adjudication. So he'll be at the panel conference. He'll discuss. He left me questions. His clerks are listening right now. So, are you both okay to go forward with that understanding? It's the Secretary first. Are you okay to go forward with this?
Yes, Your Honor. We agree.
Okay, and Mr. Eiler?
Yes, Your Honor. We agree.
Okay, thank you. And a quick note about time, as the clerk mentioned, as long as you're answering questions, you can continue. Don't worry about time as long as you're engaging directly with us. If not, you could request an extra minute if you want to just wrap up and have something to say. We've noted that the Secretary has reserved 10 minutes for rebuttal, and the Secretary here is the moving party, and so you go first, so you may proceed with your argument.
Thank you, Your Honor. Good morning. May it please the court. There is no jurisdictional hook in this case because there is no final board decision. As established by the court in Clark, the court's jurisdiction under the AMA continues to require a final board decision, one where the board grants or denies the benefits sought. In the September 2023 decision, the board remanded all issues on appeal. This is not a final decision. Therefore, the court should grant the Secretary's motion to dismiss for lack of subject matter jurisdiction. I will be presenting 2 points. First, the court's holding in Clark is binding precedent in this case and directs the outcome, granting the Secretary's motion to dismiss. And second, while the AMA made some changes to a board remand, it did not change a board remand into a final decision under the court's sole source of jurisdiction, Section 7252A. Turning to my first point, the court's holding in Clark is binding precedent in this case and directs the outcome. In Clark, the court established that the framework for determining jurisdiction, as established by the Majid line of cases, continues to be the framework for determining jurisdiction under the AMA appeal system. The jurisdictional hook under 7252A is a final board decision. In Clark, the court granted the Secretary's motion to dismiss because the board had remanded the only issue on appeal. The facts are the same here, which directs the same outcome, granting the Secretary's motion to dismiss. As the court has recognized, the holding in Clark was recently affirmed by the Federal Circuit, which makes it binding precedent in this case. If there are no questions on this first point, I will move to my second.
Mr. Yu, I have a question. So the appellant has distinguished Clark on the basis that that was a final decision regarding the motion, whereas in this case, the argument is that this is not a motion. This is actually what the appellant describes as a terminal event. Can you please state the Secretary's position on whether that is a valid distinction between the holding and Clark?
Yes, Your Honor. The Secretary disagrees that there is a distinction between this case and the one in Clark. Indeed, while the specific argument being raised in this case is different than the one raised in Clark, the legal question is the same. Whether under the AMA the court has jurisdiction over a board remand. This question was answered by Clark and by the Federal Circuit when it affirmed the court does not have jurisdiction over a board remand, and the court's holding in Clark, we would say, is binding precedent here and directs the outcome. Moving to my second point, while the AMA made some changes to a board remand, it did not change a board remand into a final decision under the court's sole source of jurisdiction, 7252A. Enactment of the AMA did not amend Section 7252A. Therefore, the existing precedent interpreting Section 7252A continues to be binding on the court. The Majid line of cases establishes that the court's jurisdiction is limited to a final board decision. And the Federal Circuit's holdings in Kirkpatrick and this court's holdings in Breeden and Clark specifically establish that a board remand is not a final decision under 7252A.
So Mr. Yu, what do you make of the change to 5103A, the new language about the duty, to review it to see if it's possible to grant the maximum benefits? Because that would seem to be a requirement, a statutory requirement placed on the secretary that would kind of precede a remand order, right? What effect does that change have? And then I guess as a related question, how would that then be reviewable?
To answer your first question, Your Honor, it does not affect the court's jurisdiction. We would emphasize again that the court's sole source of jurisdiction is under 7252A, which was undisturbed with enactment of the AMA. And specifically regarding the language under 5103 Big A, we would disagree that the court is making a decision and considering whether or not there is adequate or sufficient evidence to grant the benefit being sought. And this is a determination the board has always been required to make. And here the board found that there was inadequate and insufficient evidence to grant the benefit sought and complied with the directions of the July 2023 JMR and remanded for correction of the deficiencies in the record. As to your second question, Your Honor, if you could remind me of your second question.
So I think you said this correctly in a sense, the sequence. So the 5103A, the language indicates that basically before they would grant a remand for new development, the secretary at least has to kind of make an assessment of whether it's possible to grant the maximum benefits at that moment. One of the general principles in law is that provisions are justiciable, that it's possible to challenge them. When would that, is that language challengeable? Is that, can you challenge that language on appeal? And if so, when?
Yes, Your Honor. The arguments that Appellant seeks to raise now regarding what he has identified as that threshold determination can be raised as part of an appeal of an adverse final board decision. This is specifically the course of action prescribed in Clark. We would draw the analogy between the motion for waiver of the duty to assist at issue in Clark with the arguments that Appellant is raising now, both being interlocutory issues, and that as the court has prescribed in Clark, the proper course of action is to raise these arguments as part of an appeal of an adverse board decision. And the Secretary submits that is the proper time, that once the court has jurisdiction over that final board decision, its authority to review related matters is very broad, which would include the arguments that Appellant seeks to raise now. The logical conclusion of Appellant's interpretation of Section 5103 Big A, F2A, would result in one of two untenable outcomes. First, Appellant's interpretation would render the statute internally contradictory. If the threshold determination that Appellant has identified is appealable to the court, then under the court's holding in Cerullo, the board would lack jurisdiction to do what comes next, which is to remand to the AOJ for correction of that pre-decisional duty to assist error. However, the statute mandates that the board remand to the AOJ for correction of a pre-decisional duty to assist error. Therefore, the logical conclusion of Appellant's interpretation would be that a portion of the statute becomes invalidated. The second untenable outcome of Appellant's interpretation is that the court would be required to conduct prohibited interlocutory review. Anytime the Appellant asks this court to review a determination or finding by the board absent the final board decision, this is by very definition interlocutory review, which this court in Gardner-Dixon reiterated is not within the scope of the court's was not within the court's jurisdiction. Appellant's interpretation of the statute creates multiple steps along the way to a board remanding the issue being considered, which he describes as occurring in sequence. So he has first identified the threshold determination or the implicit denial of the maximum benefit sought. Second, he has the waiver of the duty to assist. And then finally, the board remanding to the AOJ for correction of the pre-decisional duty to assist error. However, the court doesn't have jurisdiction over any of these steps. As to that first threshold determination, this is by very definition the interlocutory review because it would precede a final board decision. As to that second step, the waiver of the duty to assist, this is the very holding in Clark. In Clark, the court held it does not have, it cannot address a motion for waiver of the duty to assist absent a final board decision or where the board has remanded all issues on appeal. And as to that last step, when a board remands the issues on appeal, it does not issue a final decision, and this is from the holding in Kirkpatrick and Breeden and Clark. Therefore, appellant's interpretation would result in one of these two untenable outcomes, either
Mr. Yu, I believe you've gone muted.
I've lost audio as well.
Yep.
Being told that I cut out.
Yeah, I can hear you now.
Okay. If somebody could tell me where
we lost about the last 30 seconds of what you were saying.
Okay. Then I apologize if I'm repeating myself. The second untenable outcome of the appellant's interpretation is that the court will be conducting the prohibited interlocutory review. And where any review by the court where the appellant asks that the court review any matter or determination by the board absent the final board decision, this is by very definition interlocutory review. And as the court reiterated in Gardner-Dixon, the court's jurisdiction cannot consider interlocutory review. Appellant's interpretation of the statute creates multiple steps along the way to the board remanding an issue, which he has described as occurring in sequence. So that first is that threshold determination or the implicit denial of the maximum benefit. The second is the waiver of the duty to assist. And then finally, the board remands to the AOJ with instructions to correct the pre-decisional duty to assist error. However, the court does not have jurisdiction over any of these steps. As to that first threshold determination, this is the very definition of interlocutory review, as it would come before the board issuing a final decision. As that second step, the waiver of the duty to assist, this is the very holding in Clark. In Clark, the court held it does not have jurisdiction to consider a waiver of the motion of the duty to assist, absent that final board decision. And as that last step, the board remand, when the board remands, it does not issue a final decision, as established by the Federal Circuit in Kirkpatrick, in this court, in Breeden and Clark.
Mr. Yu, what's to stop a board member from routinely remanding for sufficiency of the evidence or DTA, duty to assist errors?
Your Honor, the board is bound by the statutes and regulations, and under the AMA, there are limitations on when the duty to assist applies. And as such, when the board would be permitted to remand for correction of a duty to assist error.
Okay, so you're referencing 5103 Big A. Is that
correct, Your Honor? The duty to assist no longer applies once at the board level. It only applies to pre-decisional duty to assist errors. And then here that would limit when the board would be remanding for correction of that.
And the Secretary's position is that with the exception of the board being able to grant full benefits, that the VA is under an obligation to remand when there are issues regarding duty to assist errors or sufficiency of the evidence. Correct?
Correct, Your Honor. Not only does the statute mandate that the board remand for correction of pre-decisional duty to assist error, but we would highlight that in this case, the board had to remand for that correction to comply with the July 2023 JMR, where appellant's current counsel joined with the Secretary in identifying the very deficiencies in the record that the board in the September 2023 decision remanded to correct.
Okay, and is there any evidence, you referenced the joint motion for remand that obviously the parties entered into. Is there any evidence in the record to indicate that the board remanded here for a reason other than a duty to assist, error, or sufficiency of the evidence?
I don't believe so, Your Honor. The board's remand here tracks the July 2023 JMR instructions very closely.
Okay.
If there are...
And are there any other avenues for the claimant here to pursue vis-a-vis petition, other motion that would be viable if there's a reason to believe that the term that Appellant uses here is a terminal event, or there's some bad faith that is suspected here? What are the other possibilities that exist?
Yes, Your Honor, as discussed in Clark, another potential avenue available to Appellant here is that if he feels that there is unreasonable delay in the adjudication of his appeal or of his claims and issues, then he can file a writ of mandamus with this court. However, again, we would emphasize that, as established under Clark, that absent a final board decision, the court doesn't have jurisdiction. It would not be able to address the arguments that Appellant is making today.
What about a motion to vacate or reconsideration under Section 20.1000-01? Would that work here?
The Appellant could seek reconsideration of the board. I'm not entirely sure of the time frame questions that may arise, but yes, the veteran could also seek reconsideration of the board decision.
Well, do those regulations apply only to final board decisions and decisions to remand?
Yes, Your Honor. I apologize. No, that the Appellant could seek reconsideration of an adverse decision or a final decision of the board, but here where the board is remanded, that would not be an available avenue for him. I believe that's correct.
Is there any other route to get, under the legacy system? You have the Mariano errors, for lack of a better term. Is there any other avenue that's available to a claimant?
None come to mind, Your Honor. Again, we would emphasize that the court's jurisdiction is defined by statute, and as the Federal Circuit has already interpreted, there are limitations on the court's jurisdiction, and then that is binding on the court. It would limit what the board could review at this stage.
Thank you.
If there are no other further questions, then the Secretary would ask that the court grant the motion to dismiss for lack of subject matter jurisdiction. Thank you.
Thank you. Mr. Eiler?
Good morning again, Your Honor. There are 5 important points Mr. Cooper would address with the court today. In responding to both what my friend across the aisle just argued on behalf of the Secretary moments ago, as well as the Secretary's written response to the court's April 25th, 2024 order. But before addressing those points, Your Honor, from a broad overview perspective, fundamentally, this court, under the new Veterans Appeals Improvement and Modernization Act, has to discern what is still an interlocutory order issued by the board, as opposed to that which is the board's final decision under the VAIMA with respect to the benefits sought on appeal, and thus a board decision within this court's jurisdiction. In that regard, Mr. Cooper humbly submits the answer provided by the Federal Circuit, first in Maget and Kirkpatrick, is and remains, if the board will still issue another decision on the present appeal on the merits of the benefits sought, the decision is an interlocutory one over which this court would lack subject matter jurisdiction. If, however, the board will not see the merits portion of the veteran's appeal again, absent the veteran filing a new appeal, The board has issued its decision on that appeal within the meaning of Chapter 71 over which this court has jurisdiction. The 5 important points Mr. Cooper would address.
Mr. Eiler, before you leave that thought, then if that is your position, why didn't Congress address that in the court's jurisdictional statute? If that was the intention in setting this up. In other words, you seem to be arguing that Congress hit an elephant in a mouse hole here.
No, Your Honor. I mean, our position is, even in legacy, Your Honor, Congress has never addressed board remands anywhere in this court's jurisdiction. What a board decision was in legacy was a tool of both regulatory and judicial construction, looking at the surrounding legal framework, if you will, at the time. So Congress certainly was concerned about streamlining appeals and ending the endless cycle of remands. We would submit, Your Honor, that essentially what you cannot read the changes Congress did make in limiting the board's discretion and authority to remand, looking in particular at the changes at 5103A subsection E and 5103A F2A, and think Congress, Mr. Cooper would submit, didn't want there to be finality once the board issues a decision, rather than round and round the remand merry-go-round we go. Both
parties have discussed the changes that the AMA did make with respect to, for example, the lanes that can be chosen, and specifically with respect to the appeal to the board when the board remands, that the case would not automatically return to the board. So both sides agree with that, but you're arguing that in some way our court's jurisdiction changed despite these changes to the process. And the AMA is all about making the system for claimants more efficient and providing more options. So the 3 lanes, whether it's a supplemental claim, higher level review, or an appeal to the board, those are the intent. But your argument is, hey, in doing this, the process was changed, but also the board's jurisdiction or the court's jurisdiction was also changed because your argument is this is a terminal event in that it would not return automatically to the board unless the appellant here submits another NOD to get it back to the board. And yet there were no changes made to the court's jurisdiction. And as you stated, there's only one source for that jurisdiction, and the Secretary's Counsel concedes that that's the case or agrees that that's the case. So how is it that Congress would overlook this and not specifically address your position?
All Congress has ever done, Your Honor, is charge this court with reviewing decisions of the board. And that's, and I think to your question, the issue is that it's precisely because this process now is so fundamentally different that Mr. Cooper maintains that the court has to give effect to Congress's changes found at 5103A. Indeed, I think we explained in our briefing that that's precisely what we argue the Secretary did do, giving effect to what Congress charged the Secretary to do in Part 20 of Title 38 of the CFR, ending the appeal after the board issues its decision. So we would submit it's entirely consistent with the congressional mandate and the changes made by the Veterans Appeals Improvement and Modernization Act that alters what a board remand decision under the Veterans Appeals Improvement and Modernization Act is. So the 5 important points that Mr. Cooper would address with this court, as I mentioned a moment ago this morning, are first, how the Secretary misunderstands the decision the board is making when the board issues a remand, incorrectly characterizing that decision as a threshold decision when it is not. Second, why the Secretary is incorrect that Mr. Cooper's position would render the statute internally inconsistent. Third, why the Secretary is wrong when he discusses the doctrine of rightness in the context of the current appeal. Next, why the Secretary is incorrect that any determination by this court under the correct interpretation of the statute would necessarily result in remand and additional delay. And finally, why the Secretary is wrong when the Secretary argues Mr. Cooper is afforded multiple review options following the board's remand decision. Because here, to be clear, Your Honor, there is in all likelihood, there is no new and relevant evidence which exists to establish Mr. Cooper's entitlement to the benefits sought. To Mr. Cooper's first issue that he would bring to this court's attention.
Before you go, I just have a quick question on behalf of Judge Greenberg. I wanted to ask, what would you like the court to rule? How would you like the court to rule, and under what rationale?
We would like the court to rule, Your Honor, that the board issued a decision with respect to the benefit sought on appeal by Mr. Cooper when it determined that he had failed to meet his evidentiary burden to receive the maximum benefit sought on appeal. And as a result, this court has jurisdiction and denied the Secretary's motion to dismiss.
Thank you. So this is my question. Let's assume I agree with everything you say, and I'm on board. But I read the Federal Circuit's case law. I think it's Magid. I don't know how to pronounce it. Magid. And it says a, quote, decision of the board for purposes of Veterans Court jurisdiction under Section 7252 is the decision with respect to the benefits sought by the benefit. Those benefits are either granted, in which case the Secretary is bound by the decision, or denied. That sounds like stare decisis. I mean, how would we get around that?
I don't think it's an issue, Your Honor, of having to get around it. We are not suggesting that however we say the case name Maggot is somehow is overturned or not good law with respect to the legacy system. Nor Kirkpatrick nor Breeden, this court's decision in Breeden. It's the official interpretation of how the statutory term decision in 7252, which is basically our jurisdiction, the triggering of our jurisdiction is a decision, and it sets very clear parameters as to what constitutes a decision and what doesn't. That strikes me as stare decisis, which is, now you may have a great argument, but we may be the wrong court to raise it to, in that we have to follow vertical precedent. I think, Your Honor, that the issue that we would point, just as I sort of mentioned at the outset, I think that, and obviously as we argued in our briefing to the court is as significant as the Veterans Appeals Improvement and Modernization Act is. It is not. This court is always and going to have to continue to address the question of what is an interlocutory decision and versus one which is a decision with respect to the benefits sought. And so, because otherwise what we're talking about is what the Veterans Appeals Improvement and Modernization Act did, right? Was it created a class of decisions by the board that evade judicial review. And that is not something that Maget and Kirkpatrick either considered nor addressed. And so our position is that because this court is required under its jurisdictional statute to review decisions.
How did, sorry to cut you off, but I mean, how would they necessarily evade judicial review? I mean, the idea that before these same kind of interlocutory issues would automatically return to the board versus now they would come to us, that doesn't necessarily speak to whether they're effectively reviewable. It just speaks to when they're reviewable, right? I mean, you could challenge, say, I mean, at least theoretically, whether a remand for a new exam was really necessary, right? I mean, that doesn't, right? I mean, you could challenge that conceivably at the culmination of the appeal.
Not if the board continues to remand for additional developments based on an inadequate exam, Your Honor, as opposed to the legacy system, right? Where there were two options following a board remand, right? The mootness doctrine would kick in because where the issue would be moot was because the agency of original jurisdiction had granted the maximum benefit sought on appeal. So that would be the only circumstance where the appeal would not be returned to the board for a final decision on the merits. Congress dispensed with that system entirely. So now, essentially, what you have...
I mean, I understand. So, because it strikes me that, I mean, there's... So whether something's final and whether it's decision are not one and the same thing, right? I mean, finality, at least kind of classically in the APA context, is whether something's the consummation of the agency's decision-making process, right? I mean, is this the last word? Are they effectively finished with this issue? So that's final. But I mean, Maggot speaks to about what constitutes a decision, and they're saying it's basically a thumbs up or thumbs down on the elements, right? Does someone warrant service connection? Does someone get compensated for this condition or that condition? That's what they regard as a decision. Everything kind of attendant to that, all the questions that would be associated with that decision, they can be appealed, but they're not the decision itself. I mean, that's Maggot seems kind of clear about that.
I mean, obviously, Your Honor, if the court here will say Congress needed to explicitly change the statutory language to 7252A to spell out and say, P.S., this court, the Veterans Court, has jurisdiction to consider remand decisions by the board under this new law. You're right. We can't pretend that Congress changed the statutory language of 7252A, but the way we read and understand Maget and Kirkpatrick is that what the Federal Circuit did there was it looked at the surrounding legal framework, as I mentioned sort of just a moment ago, and determined to say, no, this is not a final decision by the board within the meaning of then 7252A and 7266A. Congress, by what it has charged the board with doing, and also the way the Secretary has implemented that law, has completely changed the undergirding of those decisions, while not still changing what the decisions speak to, which is the analysis of whether it's an interlocutory decision, because the board has yet to reach its final decision on the appeal, as opposed to, and as I hope to get to one of the points sort of later on, whether it is the terminal point in the appeal. Because obviously if it's the terminal point of an appeal, as it is for Mr. Cooper in the instant appeal, he's effectively done, because he cannot come back to the board on the same evidentiary record. He cannot come to this court on the record that he wanted the board to consider. That cannot happen, despite the Secretary's assertions to the contrary. So in fact, perhaps I'll move to that, which was going to be my last point first, which is the Secretary simply wrong to suggest that a veteran can go back to the board on the same appeal. They cannot. They cannot go back to the board on the same evidentiary record. Congress has forbidden it. An appellant will only be provided with, as the Secretary describes it, quote, multiple review options if they initiate a new appeal with new and relevant evidence to perhaps return to the board.
But presumably the evidentiary record is going to be different if the remand is based on a duty to assist error or a sufficiency of the evidence. There's going to be something else, is there not? I mean, can you provide a scenario where there wouldn't be something added to the record?
Where there may not be able to be something added to the record, Your Honor, because understand that to get back there, to Your Honor's point, right, there has to be new and relevant evidence, right? In Mr. Cooper's case, let's be clear. He submitted the record that he wanted and elected the board to consider. He submitted a copy of the Checo report years ago to the agency of original jurisdiction. It's already in the record. His entitlement to an earlier effective date is by operation of law pursuant to the correct application of 38 CFR 3.156C3. As we explained,
some evidence. I'll ask you the same question that I asked Mr. Yu. Is there some evidence that you have in the record that the remand is as a result of bad faith?
No.
Is this an overlooking, or do you have evidence of bad faith in the?
No evidence of bad faith, Your Honor. Just simply prejudicial error by the board. And that's what, the issue is that if the board didn't adjudicate his appeal correctly, as we explained, Mr. Cooper already threw the kitchen sink at this appeal years ago. Any evidence he would be able to offer at this point would almost undoubtedly not be new and relevant evidence, but duplicative of what's already in the record. Duplicative evidence we'd submit is almost certainly not new and relevant evidence. The Secretary's position, Your Honor, divests from the veteran's ability to control the veteran's record that he or she wants the board to consider. The greater choice alluded to by the Secretary.
I mean, on that point, so this is just kind of a practical question, right? Which is, things get really complicated if there's jurisdiction, if the court's trying to act on something and then the agency's trying to act on something at the same time, right? It can get just practically complicated. I mean, if we were to take jurisdiction over remand orders, we would basically be kind of micromanaging the evidentiary process, right? I mean, what you would be asking is, we would then make these determinations as to what constitutes new material evidence based on this record and whether, I mean, that's an overhaul of how VA's evidentiary development process would come, with the court kind of superintending the whole thing. How does that work practically?
I think, Your Honor, one thing and I guess this kind of jumps to one of the other points Mr. Cooper would raise to the court's attention. It's sort of this argument. I think you're asking sort of about, how it would operate, right? Which is, nothing that Congress did under the Veterans Appeals Improvement and Modernization Act, right, requires a veteran who is dissatisfied finds the remand that the board issued in their appeal non-objectionable because maybe they'll get the full relief they sought on appeal. Nothing requires that veteran, right, from a strategic standpoint, from saying, okay, I will see how the board here has a really good point. Maybe I will still get the full, the maximum benefits that I'm entitled to.
Would VA have to necessarily wait 120 days following every remand to just allow an appellate period to pass so that they knew that the veteran wasn't going to challenge the remand?
Right. Well, but it works both ways, Your Honor. From the veteran's perspective, the Secretary made this argument about ripeness, which was one of the issues that we hope to address with the court today, which basically, the Secretary's position, well, it's not somehow ripe, right? Because, the AOJ is still going to act. But, really what the Secretary is doing when the Secretary's made that argument in the response to the court's April 2024 order is saying, well, you can't file a notice of appeal, or maybe you have to wait until day 119 or 120 to see if your appeal to the court would be ripe, because you have to wait to see if the AOJ is actually going to correctly implement and grant you the full benefit sought. But, Your Honor, our position is, and would encourage you to ask my colleague on the other side, my friend, whether this is actually the Secretary's position. Is the Secretary really somehow suggesting that a veteran is supposed to wait until day 119 or day 120 following the board's decision to file a notice of appeal with this court? We would submit that argument's not remotely consistent with the plain language of both 7252A and 7266A, which
I appreciate what you're saying, and I think generally just about everybody who's familiar with veterans law will appreciate the harm that you're pointing out, which is these remands take a long time, the development process takes a long time. There's a lot of cases, but I mean it strikes me. I mean the particular development timelines about why the remands are going to the end of the line. That's a statutory problem, right? That's not a VA's regulatory problem, is it?
It shouldn't be, Your Honor. It shouldn't be a statutory if based upon the proper operation of 5103A, based on the proper operation, because Congress said.
But I mean, I appreciate your 5103A argument, right? I mean, VA has the statutory authority to grant benefits. They have a statutory requirement to make a benefits assessment prior to the remand under 5103A. So I mean, I recognize all that, but where in the queue? I mean, they could expedite these remands so that a lot of the harm that you talk about could be mitigated. Do the development, get it back to us in 90 days. I mean, they could theoretically expedite these, but it strikes me the statute requires, the kind of just to get back in the queue, and it kind of dictates which place in line the post remand NOD gets.
Well, but I mean, Your Honor, I think, the Secretary talked about additional undue delay, right? That this would cause. But I mean, this court's decision in Williams just earlier this week, 2 days ago, I believe it was, or sorry, it was last week. Basically under this court's decision in Williams now, if Mr. Cooper is not granted total relief whenever the RO gets around to issuing its implementing ratings decision, he's going to have to wait at least a year before he can even hope to get another decision from the board on a new appeal. The Secretary's argument that a board remand neither grants nor denies a veteran the benefit sought means, according to the Secretary, the improvement part of the Veterans Appeals Improvement and Modernization Act is effectively the board's improved ability to deny a veteran getting judicial review, creating a class of decisions, right, that cannot get judicial review unless and until the Secretary gives the green light. And until the Secretary says, okay, I'm going to permit this, right, because I'll either issue a grant or I'll issue a denial. And so therefore, and we would submit that that's simply not what Congress did when it passed the statute. It created finality in these decisions that when the board issues these decisions. Essentially, as I mentioned a moment ago, the greater choice alluded to by the Secretary is in fact a narrowing of choice with respect to judicial review, because essentially the Secretary can say, well, I'm sorry, you're just not quite there yet, so you have to go to the back of the line and perhaps try again. Because the changes that Congress made, again, we would submit, this court has to give effect to the changes that Congress made at 5103A and to the finality of this process, right? Unlike the round and round process we went through with legacy, to say, okay, granted that review, one of the points that we hope to make to the court today was about the argument by the Secretary that somehow this position would render the statute internally inconsistent. It does not do so, Your Honor. The Secretary simply misunderstands the statute's operation. We explained in our response to the motion to dismiss, if a veteran cannot waive the duty to assist, or there is no waiver by a veteran of the Secretary's duty to assist in a given appeal, if the board determines it cannot grant the veteran the maximum benefit sought on appeal, and there happens to be an error by the agency of original jurisdiction and further development would be helpful toward that end, the Secretary is right. The statute requires the board remand. As we explained in our response to the motion to dismiss, Your Honor, the Secretary could be here today arguing precisely this, affirmance. This court should affirm the board's remand, were it the case that Mr. Cooper had either not waived the duty to assist or could not waive the duty to assist, which this court hasn't spoken to. That's how the statute operates. Let's have the affirmance debate. Mr. Cooper would submit the Secretary is not here today saying, yep, look at 5103A, look what the board did, right? And that's the affirmance discussion. That's the operation of the statute that Congress wanted. That's the way to give effect to the changes that Congress made as part of the Veterans Appeals Improvement and Modernization Act. And again, we would submit the Secretary is not doing so because the Secretary misunderstands the operation of the statute and what the board is deciding before the board decides whether to remand. One of the other issues that Mr. Cooper would bring to the court's attention, Your Honor, is that we believe the Secretary in his response misunderstands the nature of the decision the board is making. And I think that this is an important point to highlight, characterizing that decision as a threshold decision. The Secretary in his response to this court's order seized on language that Mr. Cooper granted used to characterize the decision as a threshold decision when it is not, but as a decision on the merits of an appeal the board will not see again. When Mr. Cooper used the term threshold, seized upon by the Secretary, he was simply identifying the sequence of decisions the board makes and when the board makes its decision with respect to the benefit being sought. To be clear, the board makes its decision on the merits of any veteran's appeal at the threshold before deciding whether to remand.
I'm going to double back to kind of a line of questioning, I had before, which is, veterans law is not the only area of law that uses the term final, right? Pretty much it's ubiquitous within administrative law, right? And so there's a bunch of Supreme Court cases on what renders something final. And it basically is two parts. One is the decision, the consummation of the agency decision-making process. And second, is, do legal consequences flow from the decision, right? And that's a big, and it strikes me that the magic decision about what constitutes a decision is basically because legal consequences flow from a grant or a denial of benefits. I understand what you're saying, that there's a determination, at least about 5103A, that's made implicitly, at least, every time you remand. But that's not, how is that, what legal consequences flow from that? It's, you can still, they're basically still going to develop the case, assuming the person still contests it, they could file an NOD, they could adjudicate it. It's not like any final legal consequences flow from that.
They do, Your Honor. I mean, the simple fact of the matter is, particularly here in the instance of Mr. Cooper, as I mentioned a moment ago, just even looking, I think, under, whether it's Black's Law Dictionary, whichever dictionary, final, right, would at least mean that if something is non-final, right, then there is something which follows it, right? And what we're saying is there's nothing from the board in a Veterans Appeals Improvement and Modernization Act remand that follows from the board. It is done. It is done with that appeal. And so now the veteran is essentially in the same position they were as if they had a decision, if it's not a full grant, on the benefit sought. And they will have to identify the legal consequences that flow from that are that your record.
It strikes me the only difference. I appreciate the time element. I mean, that's real. But it's basically now the veteran gets an election as to whether to challenge it, whereas before it automatically returned to the board. I mean, that's the fundamental practical difference.
But the tools available to them are simply not the same, Your Honor, and may not be the same, because obviously, as you know, the records in these cases are everything. How the veteran's burden of persuasion to establish entitlement to the benefit sought. And so the legal repercussions of this is that, look, I mean, assuming that there's new and relevant evidence, because of course what a veteran cannot do is say, look, okay, this is the way the regional office implemented this, right? I mean, if you look at the decision in this case, right? I mean, assuming that there's the correct implementation of this board order at issue in this appeal, right? It will simply be an implementing decision by the AOJ, an implementing decision that he cannot go back to the board in the direct review docket because the AOJ ostensibly correctly did what the board here ordered the AOJ do on remand. So he can't get back to the board in the direct review lane. He has no new and relevant evidence to submit, so he cannot go to the evidence lane. Anything that he provided in a hearing similarly might be duplicative. He can't file a higher level review of the board decision. So it's absolutely the case that there are legal implications of, to your point, about what is a final decision by the board that leaves the veteran in a fundamentally different position that they were prior to the board's issuance of this decision.
I appreciate your argument that it spans out a lot of different directions, right? And I mean, one direction is the ability of a veteran to kind of control the evidentiary process, right? The ability of a veteran to kind of control what the record is, over and against the ability of the VA to kind of control what gets in the record. But that's a different issue than whether something is fundamentally final, or whether you can add evidence, how you can add evidence, how that process. That seems largely kind of a step or two away from what we're talking about here.
But then I think you have to also, that, Your Honor, I see that my time has expired.
That's fine. As long as we're asking questions, go on.
Yes, Your Honor. So to write, but also it's, I think, important to note that under the Secretary's implementing regulations, right, of what Congress did, that appeal is at its end. Okay. And so what we're talking then is we were talking about maybe the initiation of a new appeal on a different record, but I think it is, we would respectfully disagree with the characterization that, like, well, there's, and again, it goes to this issue of, the Secretary's successfully sort of blurring the lines here about what we're talking about with respect to, an appeal. What an appeal is, Your Honor, is an appeal is a record. An appeal is on an evidentiary record that basically says this is what's wrong here with the decision that was made. And so essentially, and this goes back to Congress not changing veterans' right to one review on appeal under 38 U.S.C. 7104. So he has right to one review on appeal. That Congress did not change. And instead what it did, again, this goes back to really the argument I made initially, which is when you look at, again, the surrounding framework, the fact that this does not go back to the board again on the same record because it cannot. And and Congress wanted it that way, to end the endless cycle of remands. So if I've answered your question, Your Honor,
I just have one last question I want to double back to, which would be, this would sort of expand the role of this court, definitely vis-a-vis VA. What you'd be asking for is something like a kind of halftime determination, like almost like a directed verdict, right? You would be asking us to rule about the state of the evidence at a given moment during the process of the development of the case. I want to ask about just how that would, if that would expand the role of this court. And second, it would seem to require a fact-finding ability that the Federal Circuit's made abundantly clear that we lack. They have been repeatedly clear about our limitations in the ability to kind of assess the record in an unmediated way. So what would you say to that, both the expansion and the fact-finding question?
No, I wouldn't characterize it, Your Honor, as an expansion. It is in part in that, essentially to end the endless cycle of remands that Congress was concerned about and addressing. You have all your tools in 7261, right? So you have all your tools still in 7261. So when the board issues a decision, right, that doesn't grant the veteran the maximum benefit sought, what's that going to be predicated on? That's going to be predicated in part on factual findings, which this court may not reverse unless those findings are clearly erroneous based upon the record. So essentially, one of the things that a veteran likely raising a challenge to a remand that the board issues is, no, on this record, my record, there's failure by the secretary to grant the maximum benefit sought. That I would imagine this court will review only for clear error. But it doesn't still mean that you wouldn't have your other tools with respect to 7261, because maybe the remand, to Judge Laurer's concern earlier, not that it's necessarily predicated on, we have no evidence of bad faith, but just simply that, look, this is the reasons and bases for this remand make absolutely no sense in light of the evidentiary record. We need to clear this up so that the veteran on remand, will actually get relief if that's what needs to happen. So, but certainly, and what's the secretary going to be arguing? Well, the secretary is going to be arguing the new and improved 5103A. That's what the board did. The board did its job here in deciding that remand was appropriate.
But presumably Congress was well aware, for example, the language from Kirkpatrick, the Federal Circuit case in 2005. So they know because the board is within the Department of Veterans Affairs, repeated appeals of board remand orders would necessarily interfere with the agency's internal processing of claims in a manner unlike this court, meaning the Federal Circuit's review of the veteran court remand orders. So this is something that Judge Toth asked you about earlier. So the point being that Congress presumably was aware. Granted, this was pre-AMA, this was under the legacy system, but was aware, and the Federal Circuit took note of the fact that giving our court the ability to review the board's remands would interfere with what's going on at the agency level. And so this was an issue that, we can all agree how frustrating and how significant the delay is for veterans. I haven't heard any party or any judge today disagree with the significance of that. But this is something that was recognized. And back to my earlier point, This is something that presumably Congress was well aware of and yet did nothing. Again, hiding an elephant in a mouse hole to address in any way, shape, or form, either directly in our court's jurisdictional provisions or in some other way. And I understand the argument, but it keeps coming back to this issue.
I guess, Your Honor, I would say then, Mr. Cooper's position would be that the changes to 5103A, that the courts, this court, should not review that to basically have been a nullity, which is that, well, it's changed, but it fundamentally hasn't changed anything with respect to either the board's discretion or jurisdiction to remand. Basically, like we can't do anything about these changes to 5103A. Obviously, we disagree. Obviously, as I mentioned, I think earlier to Your Honor, we acknowledge, right, that Congress didn't change the language at 7252A or 7266A, but nor did it change the language at 7104A and the veteran's right to one review on appeal by the Secretary. So, and it's never addressed board remands. It didn't under the legacy system either. So we would also just say, Your Honor, I think in light of the Federal Circuit's decision in the MVA case, right, we know now from Kearns and other cases that we can have issues that are at this court appropriately and issues that are before the agency. And as far as the interference with the agency, I think, Your Honor, what we would say is to the extent nothing changes about even say here for Mr. Cooper, if we're wrong, right, and on any given case, the agency from agency proceedings grants full relief, well, then that's great, because obviously the veteran's gotten what they should have gotten under the law. It's a Solzy notice. It's an unopposed motion to dismiss. It's paperwork at that point. Clerk's order stamps approved. We move on. So we would submit. We know that can and is happening, and that was by design, by what Congress wanted. But what they did also want, we'd submit, is finality following a board's decision. Your Honor, if there are no other questions, I would just simply briefly close by noting that the improvement of the Veterans Appeals Improvement and Modernization Act was not, as the Secretary submits, an improvement of the Secretary's ability to stiff-arm judicial review. We respectfully submit this court has jurisdiction of the instant appeal as a matter of law.
Good. Judge Laurer, do you have any more questions?
No, thank you.
Okay, great. Thank you, Mr. Eiler. Mr. Yu, do you have anything in rebuttal?
Yes, Your Honor. Just a couple points I wanted to clarify. First, as this court recently recognized in Jackson, although the AMA overhauled VA's claim and appeal system, it didn't overhaul the merits of all that came before it. So this is a situation where even though under the AMA, the court needs to be giving effect to the changes when the enactment of the AMA occurred, it must also give effect to those things that were not changed. And as Judge Laurer alluded to, here 7252A was not amended, and Congress is well aware of the binding precedent interpreting 7252A, specifically the Majid line of cases, which establishes, again, that a board remand is not a final decision under 7252A, and therefore the court would not have jurisdiction over those matters. As a second point, the Secretary, again, continues to disagree that the remand is a terminal event, that 5103A does not import finality into a board remand. The Secretary disagrees with Appellant's counsel that regarding this terminal event, because the adjudication of Appellant's claims will continue after the board remands the issues to the AOJ. The AOJ will conduct necessary development in compliance with the remand instructions and then issue a decision granting or denying the benefits sought, at which point the veteran can choose one of the three appeal options under 5104C, and that would continue the adjudication of Appellant's issues. We would again emphasize in this case that the board had to remand the issues on appeal for further development to correct the deficiencies in the board in the record as identified by the parties in the July 2023 JMR. And so, again, this is a situation where the board has remanded all issues on appeal. Therefore, it is not a final decision, and the Secretary asks that the court grant the Secretary's motion to dismiss. If there are no further questions, I will conclude here.
Thank you. Well, normally in court, we walk down to greet the parties. We can't do that today, but I wanted to commend both of you for a well-presented case, well-presented arguments, to thank you for your understanding. And this case is taken under advisement, and the case is submitted. Thank you.
The court is in recess.